frankly, I was fascinated by Justice Kennedy's question about the public domain. And so, Tony, he pushed you first, but I'd be interested in each of your sort of views about this. He wanted to know, so the claim is that there's something about the status of a work in the public domain, meaning it's no longer, it has no copyright exclusive rights attached to it. And he wanted to know, how should he be thinking about that status? Is that merely a conclusion? Is it a label for saying there's no copyright? Or is there some affirmative commitment to the public domain, either in the Constitution or otherwise, that the court should be giving effect to? And he appeared to be struggling with that question. And so I'd be interested in each of your sort of views about how to answer that question, because there wasn't enough time in the argument to fully respond. And I don't know how you can take it in whatever order you want, but.
Sure. Excuse me. So when you think about the public domain, and what's relevant here is when we hit the limit Congress picks, that's the point Congress chose to place these works into the public domain. And there's no doubt in the world that creates affirmative rights. The Supreme Court has recognized those rights. They called it the affirmative right to copy and use works in the public domain. And that right has been recognized all the way back to 1790, again, before there was a First Amendment. Everybody understood that once Congress makes that call and places that work in the public domain, it's public property, everybody has the affirmative right to use it. States can't come along and take it away. That's preempted. We even interpret federal statutes not to stomp on those rights.
And let me just ask, in your view, is that because it comes back in the speech context, is it anything other than a speech right protected by the First Amendment?
Yeah, I think to understand what the limited times restriction means, you have to understand how it fits into progress. Limited times is the mechanism that ensures copyright is going to, in fact, promote progress, because it tells Congress, you have to pick a date that marks the end of protection where we all know that we can use it. We can use it freely, we can distribute it, we can adapt it, we can build on it. That is the point at which everybody is free to put these works to their highest possible service in furtherance of the values in the preamble, the promotion of progress, the creation and spread of knowledge and learning. It's a mechanism to fulfill that goal. So when you talk about what the public domain means, it's the guarantee that the copyright clause delivers to the public. It is the ultimate destination of every copyrighted work. It's the fulfillment of a promise that the copyright clause requires Congress to make. It's ours. And that's why it can't be subject to revocation, because you don't know whether it's yours or not, if Congress is always free to change its mind. And if you do nothing but remove things from the public domain for the reasons we already talked about, I still don't see how you can plausibly say that promotes progress in any